Yes, Mr. Lyons.
All right, calling case number 16-000-190-01FC, People of the State of Michigan versus Geneke Lyons. Appearances, please.
Good morning, Your Honor. Parisa Kiani for the people.
May it please the Court, Francisco J. Villaru, P34147, counsel for Geneke and Antonio Lyons.
And Craig Daly, I'm going to Mr. Lyons.
All right, today's the date and time scheduled for sentencing of Mr. Lyons. Have you had the opportunity of reviewing the pre-sentence investigation report?
Your Honor, we have. I would ask the Court permission to permit my co-counsel to address the Court on the motion, because that'll have a significant impact on what the guidelines in the pre-sentence report may be in play.
All right.
Thank you. Judge, thank you. We've had a motion to dismiss on double jeopardy grounds. It's my understanding that the prosecution is essentially conceding this motion. They are indicating, I believe, that their theory is that the two different counts merge into one, so that you would only be sentencing on one count, and that in effect will change the guidelines. Our position is that the prosecution has to elect between the two counts. They were separate counts. They were not separate theories. So I'll let the prosecutor respond to that.
Your Honor, at this time, we would ask to merge the two counts to one count of involuntary manslaughter with two separate theories of conviction. This happens in a similar circumstance where you have first-degree premeditated murder and first-degree felony murder, and they both are a murder one conviction. And as we proceed forward on that type of case, it's proceeded as one conviction, but two separate theories allow for that conviction. We would ask to do that in this case, Your Honor, with the manslaughter being under the theory of the grossly negligent performance of the act and under the theory of dangerous animal causing death.
So our position is you can only sentence, given the election, Mr. Lyons on one count of involuntary manslaughter.
All right. Well, the Court's going to merge the two into one. By statute, the dangerous animal causing death, if there's a conviction on that statute, terms it as being involuntary manslaughter. And so ostensibly, it's the same conviction, involuntary manslaughter, but on two different theories. And for that reason, the two counts will be merged into one, that being of involuntary manslaughter.
And you are granting the motion?
Yes.
Thank you.
All right, so now, let's go over the guidelines. Premise upon that inclusion.
Yes, Your Honor.
In regard to the PRVs, they're all scored at 0, save for PRV 7 at 10. Is that accurate, sir?
Your Honor, at this time, PRV 7 should be scored at 0.
Are there any other PRVs that should be scored?
Not from the people, Your Honor.
No, Your Honor.
All right, so we have a total PRV then of 0 PRV level of alpha. Is that correct?
Yes.
We agree.
All right. In regard to the offense variables, OB3 is scored at 25 points. Is that an accurate score?
The people would agree, Your Honor.
We agree.
OB5 is scored at 15 points. Is that an accurate score?
Yes, Your Honor.
We object, Your Honor, to the scoring of OV5, the 15 points.
Say why.
Your Honor, OV5 talks about psychological injury to a member of a victim's family. We have absolutely no evidence whatsoever on this record, nor has any information been submitted to corroborate, confirm any type of psychological injury to anyone. So I believe that absent that information or that cooperation, they should be scored at 0.
Even though the testimony of Ms. Strickland was evident to the court that she was overwhelmed with emotion at the time that she was giving testimony in regard to this case.
I'm aware of the testimony, Judge, as the court is. The way the guideline reads is a serious psychological injury requiring professional treatment occurs.
Which may require psychological treatment. That's a very important word, may.
Well, Judge, I'm reading it. It says serious psychological injury requiring professional treatment occurred to a victim's family member, and it cites a statute, MCL 777.35, parent 1, parent small a. I don't see the word may on this guideline workbook that I have from the Michigan Sentencing Guidelines Manual. So that's our position, Your Honor.
Okay, people.
Your Honor, as you indicated, right next to where the portion that defense counsel read is the instructions, which explains how to score, which is in every single offense variable, and it specifically says score 15 points if the serious psychological injury may require professional treatment. So that is actually in the guidelines, it's in the instructions, and an explanation of how to score 15 points. I would also note that, as Your Honor indicated, Ms. Strickland testified to how she was overcome, to how she tries to forget this. There's also in the pre-sentence report, she talked about being traumatized by this and how she needs to go to counseling and how she's going to start going to counseling. So we don't need it, but we do have evidence on this record for Your Honor to score.
We don't need to traumatize the mother any further than what she's already been traumatized, honestly, by going over this in court. You may feel as if this is a judicial determination of a fact. So be it.
I understand.
In my opinion, any parent who saw and experienced the death of their child in such a manner as was unfortunately the end result of Xavier Strickland, and for that matter, any other person's child, as was commented upon during the course of the trial. We had 3 grown men, at least, in the jury, who were crying watching this video. Now,
Your Honor, I would only add...
OB5 will be scored at 15 points. Go on to something else.
Yeah,
OB8 is scored at 15 points.
Judge, just if the court would permit me just to note the objection that there was no finding by the jury, there was no determination made by the jury of any psychological injury, and under case law, we don't believe that the jury having not dealt with that issue beyond a reasonable doubt. We don't believe that that's appropriate, but my objection is noted.
Yeah, sure.
Okay.
Have to take it up to the Court of Appeal. All right, OB8 is 15 points. Is there any objection to that?
Not from the people, Your Honor.
Your Honor, OV8 we believe should be a 0. That guideline talks about a victim was exported to another place of greater danger, to a situation of greater danger. Certainly there was no evidence that this defendant took any action with respect to that. wasn't even around at the time that this child suffered what he did. So we believe that scoring is inappropriate.
Why do you believe it should be scored at 15 points?
Your Honor, nowhere in the jury instruction does it indicate the defendant himself needed to be the person that escorted the victim. The dogs took Xavier from the street under the fence to an area where he could not be helped. People were trying to help him. He was taken to a place of greater danger. That happened as a result of the defendant's gross negligence. It happened as a result of that these were the defendant's dogs, the hole in the fence was the defendant's, the security in the fence was the defendant's. It was only when the officers came, broke in, and started shooting that the attack was stopped. And had the dogs not dragged Xavier under the fence into that area, it's very possible, in fact it's likely, that the attack would have been stopped. And so in the spirit of what this means, the purpose of this is that the victim is put in greater danger as a result of the offense and that's what happened in this case. So that's why we think 8 points is proper. The dogs did take the victim to a place of greater danger, and that resulted in the loss of his life.
What you're saying is that the viciousness of these animals and their desire to have their conduct unfettered by dragging the child under the fence and into the center of the courtyard where this principal mauling occurred should be imputed to the defendant.
That's not what I'm saying, Your Honor. I'm saying that given that his dogs took this young boy and his hole and his gap in his fence that he knew about was there, and they took him to the yard, that's part of his gross negligence. That is his gross negligence.
So
and because
what you're suggesting to me then is that if these vicious animals attacked Xavier on Hayes Street, the service drive, and continued to maul him there, then the people would be in agreement that OV8 should not be scored.
That's correct, Your Honor.
I see. Well, OV8 is not going to be scored. OV8 is scored at 0. I'm not going to impute the conduct of these dogs to the defendant. All right. Now, in regard to the rest of the OVs, they're all scored at 0. Is that accurate scoring?
The people would indicate that OV6 should be scored at 10 points, Your Honor.
Say what?
Your Honor, OV6 says that the offender, for 10 points, the offender had the intent to injure. It lists a bunch of different reasons, and it says, or there was gross negligence amounting to an unreasonable disregard for life, which is exactly what we had here. That is when it's a manslaughter case, OV6, the proper scoring is 10 points. So we would say that the proper scoring of OV6 is 10 points, given that.
Rule?
Well, Judge, we disagree with that.
Say what?
The instructions talk about the 10 points must be scored if a killing is intentional within the definition of second-degree murder or voluntary manslaughter. This is not what happened here. What happened here was, as now these two crimes have been merged, was the negligence, the gross negligence. But the instructions tell us otherwise, so I don't believe that applies.
OV6 will be scored at 10 points. Any other OVs that should be scored?
Yes, Your Honor. The people would ask that OV9 be scored at 10 points.
Say what?
That is 2 to 9 victims, Your Honor. Ms. Strickland was a victim. The officer, Sergeant Wright, that had to shoot the dogs as they were coming at him when he was trying to save the boy. There was multiple victims in this case. There's no requirement that the victims be injured or hurt, but they were placed. If you look at the instruction, it does say that for 10 points, 2 to 9 victims were placed in danger of injury or loss of life. And I believe that there is ample evidence on this record to show that Xavier was not the only person placed in danger. But for the officers shooting the dogs, he may have been in danger. But for the officers chasing the dogs, other people may have been in danger. And so I think 10 points is properly scored for OV9.
Well, Judge, what may have been is not what happened here. There was.
What do you mean? What may have been?
Well, she's talking about if the officers hadn't done this, then this could have happened. If the officer.
Didn't didn't the police officers have to kill the dogs in order to even get at Xavier?
The judge may recall that there was one dog that...
Wasn't the mother knocked down by the dogs in her futile effort to try to save her son?
Well, the video reflects, Judge, we don't know what actually the jury found as a fact, but what we do know from the video is that she fell.
This is what they saw.
I understand what they saw, Judge. We all saw it, but
Yeah.
Different people can see things differently, and we don't know what the jury ultimately found. What the jury ultimately found was that this was a gross negligent situation, and that's why they found him responsible. But they made no finding whatsoever with respect to any injury or any harm or any count.
The dogs attacked both of them, didn't they? Didn't the dogs, when they were running down Hayes Street, attack both Xavier and Miss Strickland?
Well, I'm not going to concede that point, Judge. I can
Well,
tell
I know
you.
you won't concede.
I can tell you that the video shows the dogs running at both the mother and the
And the
child.
mother then was knocked down by the dogs as they
Well,
left the
no,
barn.
Judge. Again, that's a question of
Maybe
interpretation.
you need a new set of glasses. OB9 will be changed from 0 to 10.
Thank you.
Any other
I
OBs
wasn't
should
being
be struck?
disrespectful to you.
What?
I wasn't being disrespectful to you in my argument, Judge.
I didn't think you were.
Okay. Well, all right. I'll take the suggestion on the glasses.
Good. All right, any other OBs that should be altered?
Not from the people, Your Honor.
No, Your Honor.
All right, so we have a total OB scoring then of 25, 40, 50, 60. Is that correct?
Yes, Your Honor.
Does that change the OB level from 5 to 6?
No, it still remains a 5.
That, coupled with a PRV level of alpha, gives us a guideline range of, say, what?
Your Honor, it is
19
19 to 38.
Madam Prosecutor, it's my understanding that Ms. Strickland wishes to address the court. Is that true?
Yes, Your Honor.
Mrs. Strickland, good morning.
Good morning.
Okay. The whole community mourns for the loss of your son. You know that.
Yes.
You can sit down. You don't have to stand up. All right. Do you want to say something to me?
Yes, Judge.
Go ahead.
This has changed. Every time I think about him, I get upset. I wake up in the morning, I kiss his picture that's on the little stand by my door. When I walk in, I kiss his picture. I think about him every day because that's a part of me that was taken that I cannot get back. And it has dampened me and my family. He was the last born grandson that was really in the family. And, you know, the other day my son asked me, he was like, I wish my brother was here. And I was like, I do too. It's taken a lot out of me just to move on, you know. If I could just have him, I would be okay. But I know that's never going to happen because that's the part of me that's gone. Like, that's the part of my heart that's lost, but never forgotten, you know. And, you know, the other day, I was at the school, and one of my students walked up to me and gave me a hug. and handed me a card. Forever love, Xavier. And that touched me, because to know that the community care about me and my family, that helps me get through this, because to lose a child, Judge, that hurt. That hurt. I thought my children was going to bury me one day. And I had to bury my 4-year-old son. That hurt. I can't just get him back. You know, I can't get him back. No, he does not know how it feels to bury a child. Does not know how it feels to be attacked by them animals. He does not know how you have to get up and explain to your 9-year-old that's going through something, and your children and your nieces and nephews and the family, that I don't know how I'm going to make it. I call my sister every day, and I cry. I cry. I cry. I cry. He was a blessing to us, Judge. If I was sick, I tell you, Judge, if his daddy went to work, he stayed there. He stayed beside me. When my other children was in school, he made sure. Because sometimes I would be sick, and he would, just seeing his smile would be all right. This has really dampened our family. This is, I don't understand how that he does not know how it hurts. He don't. I wake up in the middle of the night, sweat, tears. I still have nightmares to this day. Like last night, I couldn't go to sleep because I was thinking on him. Thinking. I sit in the chair in the living room and I stare at his picture sometimes. I have lost. That was all my children on my heart. But that baby right there.
He was a beautiful child.
He was the most beautiful, loving, caring. If he knew something was wrong with you, he'd walk up and give you a hug. Didn't even know nothing. But he would hug you and you'll be all right. We have lost a true pioneer in our family. That baby was, as they say, he was young, but he had an old spirit in his body. He was a true pioneer in our family. There is nothing that he could have did something about that fence. He could have fixed that fence. He could have did something.
Well, like I said to you before, Mrs. Strickland, the heart of the entire community goes out to you. No parent should have to go through what you went through and witnessing it. And we all feel terribly sorry for it, honestly.
Yes.
Ms. Kiana, do you have anyone else that wishes to address the court?
Your Honor, I don't believe so. Let me just confirm. No one else is going to address the court at this time.
All right. Do you wish to say anything further to me on behalf of the people?
Yes, Your Honor. You've obviously heard the case. You're present during the trial. We did receive defendant's sentencing memorandum this morning. It was filed with our office, and I have not had a chance to go through it in detail. I would note that they refer to factors in the federal sentencing guidelines. The court knows that at this time, under the Lockridge opinion, the guidelines are advisory. However, The court is to consider them, to score them, and if reasonable, then sentence outside the guidelines. We believe that given this case, given the loss of Xavier's life, given how preventable this was, how easily preventable this could have been, the defendant's knowledge in his business life of maintaining homes and properties, and the defendant's knowledge that these dogs had been getting out, those in and of themselves are factors that make this case, the situation, egregious. We think that a proper sentence would be incarceration. It's not a reflection necessarily on the dogs themselves or the defendant outside of these circumstances, but this is a crime for a reason, and the guidelines are incarceration for a reason. And we don't think that there's any reason, there's no justification for going beyond that. The guidelines, as calculated at this point, are 19 to 38. They're not even the number of years Xavier was alive. And his entire life was taken from him. And there should be consequences and there should be accountability. And we think that the proper sentence in this case would be at the top of the guidelines, 38 months. We do believe that the defendant owes society 38 months of his life, 38 to 15, what this court is allowed to sentence him to under the guidelines. And we don't think there's a reason to deviate from the guidelines, to go below. I believe defense is going to be asking for probation, and I don't think that any of the factors that they indicate are sufficient in this case. The facts, the nature of the circumstances, the totality, and the law supports a term of years in the Michigan Department of Corrections, as was recommended by the probation department when they did their report as well. So we would be asking for a sentence at the top of the guidelines, Your Honor.
Which of you wishes to address me on behalf of your client?
Your Honor, I'm wondering if it would be appropriate to conclude the content of the pre-sentence report. We did not conclude that, and there's a number of issues that are...
Well, I had asked you as to whether or not there was any objection or corrections to the pre-sentence investigation report. You indicated no.
No, I indicated that I would request the court's permission to allow Mr. Daly to argue the motion, because that would have an effect on...
The motion has been argued, and that's been conceded ostensibly. What else? What other aspects of the pre-sentence investigation report you call into question?
May I address them now?
Oh, certainly.
All right. Your Honor, with respect to page 1 of the report under the prior record, it's listing as one prior felony conviction. That should be 0. There are no prior felony convictions that are permitted to be noted. So that should be a 0.
It's merely bringing to the attention of the court the fact that the defendant had previously been convicted of possession with intent to deliver between 50 and 449 grams of cocaine, and for which he served 10 to 20 years in the Michigan Department of Corrections.
We know that
What else?
We know that information is there, Judge, but it should also be noted that under the law he was permitted to petition the courts for expungement, and that petition was granted on the 5th of April, 2013.
That means that it can still be taken into consideration by this court as an overall factual basis in regard to sentencing, not necessarily in regard to the guidelines, but certainly a defendant's previous history, whether it be expunged or not expunged, has to be taken into consideration by a court. Okay, what else?
Your Honor, again at page 1 of the body of the report, the second to the last paragraph right above agent's description of the offense, the entry from the probation department says sentencing guidelines work out to 36 or 71 months. That should be amended or corrected to the range that the court has found at 19 to 38.
Okay, we'll do that. 19 to 38, okay.
Your Honor, with respect to the entry under criminal justice, there are a number of entries there, just for the record, we take the same position that those entries there.
Well, be specific.
Very well. With respect to,
We don't like to have a shotgun approach to a pre-sentence
I'll be specific, Judge. I don't have a problem being
You want to
specific.
bring to the attention of this court, I assume the Michigan Department of Corrections, any corrections that need to be made. So be specific then.
Very well. Your Honor, under the criminal justice, number 1 of number 1 says that that matter was dismissed on the 29th of November, 1988. In our position is that anybody can be arrested, and if the cases are dismissed, it ought not to be part of the record, because any one of us here can be arrested. Any one of your deputies at your direction or on their own can arrest people. The mere fact that one is arrested doesn't mean that they're guilty of anything. So those entries, I think, are prejudicial. They should not be noted.
Under the juvenile history of the defendant, and that's within the prerogative of the judge who hears that and disposes of that matter at the juvenile level. But that still, as well, can be taken into consideration by a court in regard to showing what the defendant's previous history has been. So it's not going to be stricken, it's going to remain.
Very well.
Anything else?
Yes, with respect to 1 of 7, that also incorporates the expunged record of April 5 of 2013.
I've already commented on it. It will remain.
Very well.
Anything else?
Yes, with respect to 2 of 7, it indicates that the prosecution was denied on the 14th of March 2013. That should be stricken. There's absolutely no evidence or nothing on this record of any culpability, any wrongdoing. There's absolutely nothing. It's an entry, so I would ask the court respectfully that number 2 of 7 should be deleted.
And in that respect, I will agree with you. That will be scratched. Anything else?
Your Honor, with respect to...
May I just take a position?
Oh, sure you can.
I would note that it's standard to put in the pre-sentence report when someone has been arrested, which he was arrested for. It indicates the arrested agency, it indicates date, it indicates charges, and it is common to keep it in there for the same reason. Your Honor can consider it. We don't know why it's been denied.
But in fact, there are no charges. In other words, he's detained, he's arrested, but there are no charges because the prosecutor denied it.
Yeah.
So it's being stricken. Anything else?
Yes, Your Honor. With respect to 3 of 7, that matter was dismissed on the 24th of March 2008. We ask that that matter also be deleted from the entry.
And the people would object. Again, this is all stuff for the probation department, for Your Honor, and for later down the line, if needed, for them to review. His contacts with the criminal justice system, whether or not they resulted in a conviction, are a factor, and that's why they're standard in the pre-sentence reports, which is why...
3 of 7 will remain.
Your Honor, with respect to 407, that's an entry on December the 10th of 2007. Prosecution was denied. So I would ask this court respectfully strike that.
As I had ruled previously in regard to 2 of 7, 4 of 7 will as well be stricken. Anything else?
Your Honor, with respect to number 5 of 7, that matter was dismissed on the 24th of June of 2010. Again, the position is that anybody can be arrested, and if the matters are dismissed, that they ought not to be part of any record.
5 of 7 will remain. Anything else?
Your Honor, with respect to 7 of 7, and that's the entry.
What about 6 of 7? Do you want to do that one too? We don't want to skip numbers.
Well, Judge, that was a delay sentence under 771.1.
Somebody was placed on probation, right? So
I didn't raise any objections to that one, Judge, because I think that would be an appropriate entry, because it looks like he was adjudicated.
okay, good. So
That was a disorderly conduct entry.
Leave that in there. Okay.
With
How
respect,
about 7 of 7.
with respect to 7 of 7, Judge, the entry that says final charges: count 1, homicide, manslaughter, involuntary; count 2, animals, dangerous animals causing death. I think that the proper entry there should be the manslaughter, involuntary, and count 2 should be dismissed.
No. Well, count 2 is merged into count number 1. As it's listed, it will remain. Anything else?
Judge, this
I have to compliment the Pre-Sentence Investigation Department for the marvelous job they've done in this pre-sentence investigation report.
And I agree, but
Quite
this,
contrary to what I previously made comment
so,
about.
sometimes, Judge, they're very good at what they do, but sometimes lawyers have an obligation to their client to make sure that
Absolutely.
even that information is
They always
accurate.
have that obligation.
Thank you,
Please
Your Honor.
continue.
The problem with this, Judge, is it relates to the classification and designation in the event that this court imposes incarceration. When they get this document, the Department of Corrections takes this and sees it as he being convicted of 2 counts. And they incorporate that into the factors that they use in, as I indicated, classification and designation. I think that the proper entry should be, as conceded by the prosecution, that he was convicted of 1 count, whether the conduct of the count 2 was merged. It's still only 1 count.
He was convicted of 2 counts, and the 2 counts were merged this morning. It will remain just the way it is.
Very well.
Please continue.
Your Honor, at page 2 of the document entitled Basic Information Report,
Hold on for a second, you lost me.
it would be the last.
Hold on for a second, you said. What page are you referring to?
It's near the back of the report. It's an independent sheet. It's called Michigan Department of Corrections Basic Information Report.
All right, hold on for a second. There we go. On page 2, you say?
It begins at page 1, Judge, under criminal history.
Okay.
Just to, again, to note the objection, it shows a number of prior felony convictions. 1, we ask you to delete that. That should not be part of the Michigan Department of Corrections because that, too, is a factor that is considered
Well,
as
what are
the...
you referring to specifically? I
under
see the
cri-
criminal history category. All right, so now what are you contending?
There's a section there that begins, it says pending charges and goes number of prior felony convictions. They note 1. Our position is that it should be 0 because, again, for the record, that matter had been properly expunged by a court of competent jurisdiction.
I'm still trying to find what you're referring to. Yeah, I got that number of prior felony convictions. It just says 1.
Yes, they're talking about prior felony convictions.
Yeah.
He has no prior felony convictions
Yes, he does.
because that matter
Possession with intent to deliver. He served 10 to 20 years.
that matter was officially expunged, Judge.
Whether it be officially expunged or not, like
Very well.
I said, it remains. We can't rewrite history.
Well, again, for the record, our position is that a judge of competent jurisdiction deleted that conviction by way of the expungement. It should be 0.
It will remain. Please continue.
Okay. Your Honor, on page 2 of the
I'm
same...
just giving you a good basis for appeal.
Judge, I guess I go back to the position that defense lawyers have an ethical and professional obligation to
Please
represent their
continue,
clients.
Mr. Villarreal.
Thank you. Judge, with respect to the last entry on page 2 that talks about sentencing guideline range, that document also goes to the Michigan Department of Corrections, and it shows a range of 36 to 71. That, too, should be corrected to reflect 19 to 38.
So be it.
And with respect to the prior record total, it shows a 10. I think that should be a 0.
What is that premised upon?
Well,
What is the prior record total? What does that mean?
I believe that's the scoring of the PRVs and the OVs, Your Honor.
that's correct.
So our PRVs we do have at 0, and our OVs we actually have at 60 instead of 55. So the prior record total should be 0.
Should be 0. Okay.
And the
that's good.
offense variable total should be 60.
Excellent. So be it. Anything else?
And, Your Honor, I would ask respectfully that counsel for Mr. Lyons be permitted to review the amended or revised pre-sentence report before it's officially submitted to the Michigan Department of Corrections.
Certainly.
Thank you.
You don't trust my writing?
Oh, I do. It's sometimes the interpretation of the writing, Judge, that the Michigan Department of Corrections may commit a different view of what you wrote.
Okay. I think I graduated from elementary school. Please continue. What other corrections do you wish to make?
We have no other corrections, deletions, or additions to make to the report, Judge, other than those noted on the record and the objections that have been placed. And
Do you wish to say anything to me on behalf of your client?
I do, Your Honor, and I thank you for this opportunity.
Please proceed.
With the court's permission, I wish to direct some comments to Ms. Strickland that I've been authorized to make.
Say that again?
I said, with the court's permission, I wish to direct some comments related to Ms. Strickland, with the court's permission.
Absolutely not. You will not be permitted to do that.
Okay.
This is not
Your
an
Honor.
opportunity for a defense attorney to be critical
Oh, no.
of a
no.
victim or a victim's family member.
That's not the intent.
Nor to
Yeah.
change the true record of a trial in a case. So I don't know exactly. I'm trying to read into read between the lines, so to speak, in regard to what you're referring to. But you are not going to be allowed to
I'll
be
address them
critical
to the court.
of a mother
I'll
who
address.
lost a 4-year-old child. Because you know what? I still have to be somewhat compassionate for your client. If you wish to turn me into a block of stone,
Oh, Judge, not at all.
please continue.
Not at all. I think the court misinterpreted, and I will address you. I would just ask you for permission. And the comments is this, so that there is no misunderstanding about what our intent is.
These were not puppies. Let's not go into an argument like that again.
May I proceed, Your Honor?
Yes.
Thank you. Your Honor, there is, frankly, no words that, as counsel for Mr. Lyons, can be stated on this record to convey his deep remorse, his deep emptiness for the loss of this child. There is nothing on this record that would show any intent whatsoever on his part to harm anyone. So on his behalf, and he may speak, I'm not sure, we certainly communicate our sincere and deep remorse for the loss of this child. That's what I wanted to say initially to Ms. Strickland through you. It is not about diminishing the loss of this child. Absolutely not. The court presided over this trial. I think the court presided over what we believe to be a trial where there was nothing that the defense did to try to diminish the loss of this child or in any way harm the family any further.
See, Mr. Villarreal, when you first made comment that you wanted to address the comments that were made by Ms. Strickland,
I didn't say that.
well, that's the impression I got. Okay, so that's the reason that I barked back at you. No pun intended. But if you wish to express on behalf of your client the remorse of Mr. Lyons to the mother directly, you're welcome to do that. You're invited to do that.
Thank you. That was my request, Judge.
You got it.
Yeah. Thank you.
Proceed.
So as I've indicated already for this record, both to the court and to Ms. Strickland, as a neighbor and as a resident of that area, there is nothing factually that would indicate that Mr. Lyons at any time did anything.
Let's not form a defense right now. This is not final argument, okay? If you wish to express remorse on behalf of your client to the mother, you're welcome to do that. But you are not going to rewrite history, okay? This is not the time for closing argument, my friend.
It's always challenging, Judge.
Isn't it really?
It really is challenging, Judge, and after
That's why we love our profession.
That's exactly right. And we always, as officers of the court, try to be respectful to courts and to the process. So I was trying to be respectful to the process.
I think you are.
And in that regard, I sincerely meant to communicate that remorse not only to the court but also to Ms. Strickland. A remorse that I think is genuine, as genuine as anyone can manifest it. And it was background information, not a closing argument, that I was attempting to communicate to her because she's a neighbor, because she lived in the area. But having received the direction that the court has given me, Ms. Strickland, I have already, at our first hearing in this court, manifested my client's deep remorse for the loss of your child. He has not wavered from that remorse. Never. The record has other information that shows his remorse, documented by professionals, but he has instructed me and he has given me permission to tell you publicly that he's hurt by the loss of your child. And he deeply, deeply feels the pain that you feel as a father of a young child as well. Judge, you presided over this trial.
Sir.
And it certainly is not the time nor the place, as you've indicated, to give closing arguments. I'm going to focus on Mr. Lyons as a person, because as a person, courts are supposed to phantom a sentence, phantom punishment that speaks to what the law really says ought to be, and that is that you focus on punishment, true enough, you focus on protection of society, and you focus on rehabilitation, taking into account an individual of the posture of Mr. Lyons. You have ample information about Mr. Lyons, not only as part of the pre-sentence report, but also as part of the sentencing memoranda that was submitted on his behalf. And I apologize for its tardiness. I was in federal court yesterday and didn't get it to you in time. But
That's all right, I can read fast.
Judge, there is a summary of who this man is. The record knows, and you know, that he had prior contacts with the authorities. And then he came out and became a productive individual, a very productive individual. And I had known Mr. Lyons from the past. We lost track of each other. This came up, and he called me to represent him. And I was candidly overly surprised at how well he had engaged in productive activity, taking on blighted properties, dilapidated properties, rehabbing them, making homes for individuals that didn't have homes by way of rental, with the opportunity for them to own these properties. Took it upon himself without any pay or recognition by any awards to always cut the lawns and the weeds along the empty lots in the vicinity of where he lives and where other neighbors such as Ms. Strickland live. Took it upon himself without pay or recognition to shovel the snow as part of his employment that he created in his business, to make sure that the sidewalks were clear so that children could continue safely to the Thurgood Marshall Elementary School. became very active, not only with his family, it's reflected in the numerous letters. I mean, I couldn't believe that when I said, can you give me some letters of the people that know you? I know you on a professional level as your counsel, but you deal with all kinds of different people, and I was astounded by the number of letters when I was putting this packet together. I mean, it was unbelievable, the kind of person that he is, not by my word.
Copies of those letters have been provided to the Assistant Prosecuting Attorney as well, have they not?
They were received this morning, Your Honor.
Have you had the opportunity of reading them?
Not all of them, Your Honor. I just know I was able to skim through to see that they're here, but I have not had a chance to read through them.
All right. Please continue.
And not only were the letters that shows the kind of person that he is, kind, productive, respectful, always available to assist, but also a deeply religious person.
Now, we aren't looking to beatify Mr. Lyons now, are we? We aren't going to start going into religion.
When I reviewed...
I'm appreciating everything that you have thus far told me.
When I reviewed these letters, probably one that stuck out for me as his counsel was the letter from his treating mental health provider.
Dr. Chisholm?
That I think his name is Dr. Errol Liverpool.
Oh, Liverpool, okay.
And I didn't even know that he was going there until I asked him to gather letters of support. That tells you a lot about Mr. Lyons. It tells you how deeply hurt he is about the loss of this child, and how he's accepted that responsibility. He's accepted the fact that he could have done more if he had some way to bring this child back. He would do it in a second. And this professional without hopefully giving away privileged and private information, goes on to say that he was equally impressed and genuinely remorseful that a child died as a result of this tragedy. He never expected to return home from a normal day at work to be confronted with such grim news. His sense of regret was authentic, and his focus was not on the anhedonia he's experiencing, but rather on a young life that was lost and a mother's life that will forever be changed. And that surprised me. It doesn't surprise me, Judge, the family will say, he's a good person, we love him, we don't want you to lock him up. But these other letters of individuals that are not related to him tell, I think, that this individual, Mr. Geneke Lyons, true enough has accepted his responsibility, the citizens have spoken, but I think he is a person that as you fashion and put together what you believe to be the appropriate sentence, he's an individual that can be productive as he has been in the past. He's mentored kids. He went to a different state when he found out a school friend of his was now a reverend, and he proceeded to assist. There's other letters that he's a mentor to individuals that are in the streets. All these things were unknown to me and unknown to my co-counsel. And they're genuine. It shows you the kind of person that he is. He never intended this tragedy. And there's no other word other than a terrible, terrible tragedy. But I do think that the court can put together whatever combination of restrictions the court thinks is appropriate and give him the maximum amount that you can under the probationary period. And let him show you, let him show the prosecution, let him show the citizens of this state and this city that these events that lead to this tragedy can be prevented and monitor his progress. he does no good to himself or to anybody to be incarcerated. So on his behalf, Judge, I'm respectfully requesting that you consider him as an individual, consider all of the background information you have about him, the numerous letters that point out who Mr. Geneke Lyons is, and impose a sentence of probation. Thank you.
Mr. Lyons, do you wish to address the court? Please do. Stand up at the podium, all right? Okay. Good morning.
Good morning. First of all, I'd like to thank you, Judge, for allowing me to remain on bond. Second, I'd like to show my remorse for the loss of Xavier. I'm sorry for his loss. I'm sorry for the things Xavier Strickland is going through, the loss of her son. And I have a 2-year son myself, so I cannot imagine the pain that she's going through. But during the time of being locked up for 6 weeks or 7 weeks, I never got a chance to show any type of remorse or help because I was put behind bars in a split second.
This was just initially after your arrest, right?
Yes, just initially after my arrest.
But you came into this courtroom, though, I placed you on bond, didn't I?
Yes.
All right.
And I truly thank you for that, Judge.
All right.
I really do.
All right.
But at the time of me coming home and notice something, well, when I got the call and me coming home and noticed that a tragedy had happened at my house, I immediately was trying to assist to see what's going on because I have no I didn't produce any dogs to act this way or try to harbor any dogs to want to bite or be vicious to anyone, or I would have put them down myself. By the neighborhood we stay in, everybody pretty much required dogs to try to keep people from breaking in or people from or other animals coming to your facility, or even
Take your time, Mr. Lyons. Take your time. I'm listening to
it's kind of hard for me to even glimpse a thought right now because I've been going through the dealing of the loss of Xavier, and I haven't bounced back since the day it happened. This is something that's going to stick with me for the rest of my life.
This entire community has lived through this experience.
They have.
Yeah, I know.
And it's I'm really, really sorry. I mean, sorry, very, very sorry of Xavier losing his life. And I wish I could have made it back in time to save or to stop or to put the dogs down at that part. But I was just a few minutes or a few 30 seconds too late.
I know you see Ms. Strickland right there at council table.
Yes.
Okay. And you can look at her and express your feelings directly to her.
Okay.
All right? Please.
Mr. Strickland, I'm very sorry for your loss. And as a person in that community of making sure y'all get back and forth to the school, shoveling the snow, cutting down the weeds and the trees, even removing of the 2 houses that was behind me that was vacant, so no one be getting snatched up in those vacant houses. So if I could turn the hands back in time, I would love to help you through your loss. Love to help you through your loss, especially during my time of my incarceration. I even asked my attorney, could I set up a fund or set up anything to try to help with any type of expenses of anything. And I just wanted to show that I care for you, I care for your family, and I'm just so sorry for your loss, very sorry for loss. And if the judge imposed a sentence on me, and I would still try to help you through, if you allow me to, with going through the loss of your son. I'm very sorry, very, very sorry.
You wish to respond to him, Ms. Strickland?
Yes.
Go ahead.
I understand what you're saying. And I'm willing to forgive you for what your dog did. I'm hurt. Sometimes I can't sleep. I'm hurt. I call my sisters all the time because I have nightmares on how I was attacked. I'm scared to get out of my car. If I see a dog, a big dog, I'm like, oh, it's time to go. They're like, calm down, it's on the leash. I don't like dogs no more.
Okay, but you accept what Mr. Lyons
Yes,
is
I
saying
do.
here?
I accept.
All right. Go ahead, Mr. Lyons. I didn't mean to interrupt you. Go on.
Oh, that's okay, Judge. Ms. Strickland, I thank you for your acceptance of my apology. And I can't sleep either. From the day it happened, I haven't had no sleep at all. I have gained excessive weight. I haven't had a clear I'm mind bothered, and I don't know when I'm gonna ever get right. I might not never get right. So I pray that you and your family get through it, as well as me and my family and the whole entire world that witnessed this tragic loss.
Thank you, Mr. Lyons.
Should we stand at the podium, Your Honor?
Yes. The court's had the opportunity of reading through the pre-sentence investigation report and looking at the history of the defendant. And Mr. Lyons, as Mr. Villarreal had made comment of earlier in his comments on behalf of his client, touched upon a very important thing. Is that although Mr. Lyons was involved in reprehensible behavior in the past, he totally changed his life around. He turned his life around to where he became a positive aspect in society as opposed to a bane, a draw of resources, etc., on the community. That does not vitiate or take away from the terrible circumstances that befell Xavier and Mrs. Strickland on December 2nd of last year. But it does give me some enlightenment in regard to what should or should not be done in regard to you now that you've been found guilty of involuntary manslaughter of this child. True, the behavior of these dogs was terrible, vicious, and killed this little baby. And I already made comment upon the the tears that were shed by several of the men that were on the jury. And you expressed the same feeling that I think they had as well, Mr. Lyons.
Yes, sir.
I'm sure that if you were capable of or did return to your home earlier in the day to where you could have interceded and prevented these dogs from continuing what they did with Xavier, that you would have absolutely done so, even to your own peril, as would any man, honestly, or for that matter, woman. But in trying to fashion a sentence for you in regard to what had occurred, because you have been found guilty of ostensibly gross negligence, in failing to prevent these dogs from escaping from your property and running at will in the community, causing a very serious threat to the well-being of children, especially. But taking into consideration your change in your circumstances, I don't believe that lengthy incarceration of you would be of any benefit to you at all. It wouldn't be of any benefit to the community at all. It certainly wouldn't work as a deterrent. Because the conduct of the dogs, although imputable to you, because you were responsible for them, were the acts of an animals, lacking reason. Certainly you didn't intend for this child to be viciously attacked by these dogs. But it was your responsibility to have prevented their release so that they could inflict injury upon others, including Xavier. So for that reason, what I'm going to do is I am placing you on probation for a period of 5 years. This is for your violation of MCL 750.321 Charlie, involuntary manslaughter, combined with a violation of MCL 287.323 Parent 1, dangerous animals causing death, combination of the two, because we're taking them under both theories.
Okay.
However, I do not want other people who possess these type of animals from thinking that they can possess these animals without any responsibility for what the repercussions of their conduct might be. And for that reason, the first 12 months of this sentence will be spent in the Wayne County Jail. Now, because of your assistance with the community, your helping the community, and your leading an otherwise law-abiding life, I'm going to allow you to have work release during that period of time.
Okay.
Okay? Now, the probation will be intensive probation. You are to have absolutely no contact with dogs from this date forward. Do you understand?
Yes, sir.
You are to undergo DNA testing at the cost of $60, undergo a psychological evaluation and treatment, which it appears as if you may need. You're going to pay a state fee of $68, a crime victims assessment fee of $130, court costs in the amount of $1,300, and supervision fees in the amount of $480. I believe the comments that you made to me this morning and to Ms. Strickland are from your heart. And I hope none of us have to live through this kind of experience again. Now, because your conviction was by jury verdict, you do have the right to file a claim of appeal as a right to the Court of Appeals to try to overturn that conviction or to be resentenced. The Court of Appeals would have no option. They'll have to accept that claim of appeal as a right that you and your attorney would file with them. They'll also have the opportunity of having oral argument before them. And then they'll make a decision in regard to the various issues addressed. Now, that claim of appeal as a right may be perfected by you on the very form that you're signing this morning. It further explains to you in written form what your appellate rights are. If you wish to file a claim of appeal as a right, it must be done so within the next 42 days. And if you would like the assistance of an attorney in filing of it, cannot afford an attorney can and will be appointed for you. Do you understand?
Yes, sir.
Now, I know I've gone below the guidelines in regard to this sentence. And it's evident from the defendant's history and his change of circumstances that there's clear evidence in this court's opinion that this particular type of sentence is warranted in this case. Good luck to you.
Thank you, Judge.
And good luck to you, Ms. Strickland.
On behalf of,
The credit time is 43 days.
thank you, Your Honor.
You're welcome. There was one issue that has not thus far been addressed, and that being bond pending appeal.
Your Honor, my understanding is that we're going to withdraw the motion of this. My learned counselor has...
We're going to ask that you hold it in abeyance until we get a chance to speak with Mr. Lyons.
Very good. Okay, bye-bye.
Thanks, Judge.
I'm going to be doing a file argument to the case, and then I'm going to...
Thank you, Your Honor.
Okay, I'll text you.